We've got Julie Kelly with us now. A great day for her, a great day for justice. Go check out Declassified with Julie Kelly on Substack. Support her work, please. She's doing so much for all of us by bringing the truth forward on January 6th issues, but particularly you can imagine for the families of those J6 defendants. Julie has been a tireless champion. Julie, great to have you on.
Hey, Buck, thanks so much for having me on. And yes, what a gratifying but also heartbreaking day.
Let's start with what does this mean specifically for some of the people prosecuted or awaiting prosecution still relating to the January 6th incident?
So what the Supreme Court really said was that this 1512C2, the charge had to demonstrate some evidence impairment, some destroying of records or tampering with records or a document or other object, which is what the C1 part laid out. Well, what the DOJ has done, and 18 federal judges in Washington has allowed the DOJ to say, is that basically Section 2, the C2, doesn't refer to the first section that deals with evidence. All it says is that, anyone who tries to obstruct or interfere with an official proceeding is guilty of this crime. So unfortunately, the C2 part is very vague, and that is what the DOJ seized upon. They weaponized this very vague language to say that anybody who interrupted the events of January 6th was obstructing an official proceeding. You're guilty of this felony, punishable by 20 years in prison. Now, the DOJ has brought this felony count against more than 350 J6ers. About 120 of them are in prison or have already served prison time because DOJ sought years in prison for conviction or plea deal of 1512C2. So that means there are probably about 200 cases still pending. Some judges have already dismissed the count or have held off any trials or plea negotiations on that count, waiting for the Fischer decision, which we got this morning. Some judges have even released a handful of J6ers who are in prison on this count, saying, okay, you've already served your time for a few misdemeanors. This was the driving, and it has been, it has been the driving charge that have put people in prison for years. So it's going to be very complicated what will happen in the D.C. courts. But they were already preparing for a flood of motions, which I assume will be starting today, to grant relief to these defendants who have been wrongfully prosecuted by Joe Biden's DOJ.
Okay, let's also talk about what this does for Trump, because we're still waiting on the presidential immunity case. And let me just say this, too, by the way. And I know a lot of our audience knows it, but it really does deserve to be repeated a lot. Julie, you've done incredible work on these Jan 6 related cases and also on chasing the lawfare. And you have nailed so much of this. And there have been a lot of people out there, I know, taking pot shots at you saying, oh, she doesn't have any idea what she's talking about. You started coming on talking about this Fischer case with us years ago, laying out what was likely to happen, you believed. And now you've been validated. So congratulations to you on this and props to you. And I encourage everybody to go subscribe to your Substack. Now back to the praise. Let me go back to the second part here. This is basically half of the charges, to my understanding, that Jack Smith brought against Donald Trump related to Jan 6. How do you think this impacts Jack Smith's D.C. case? And presuming we get some sort of presidential immunity ruling next week, probably on Monday, where does that case go from here?
I mean, look, his 410 indictment against the president as of now, and of course the immunity ruling on Monday, is in a very precarious condition because 2 of the 4 counts relate directly to 1512C2. And if the Supreme Court, and it kicks it back to the lower courts, and this is where Jack Smith's indictment is, Judge Tanya Chutkin, the D.C. District Court, and the burden of proof has to demonstrate that his actions involved evidence tampering, destroying records or impairing any sort of document, an investigation or official proceeding. That really raises the bar for Jack Smith. Now, what's funny, he's already signaled that he will use the so-called fake electors, the electoral certificates that people produced and sent in as to meet the document or evidence impairment burden. Now, how ridiculous does that sound? Absurd, but that doesn't mean that Judge Chutkan isn't going to allow it. So we'll see what he adds or how he's going to deal with this in his existing indictment. Then, of course, we have the immunity ruling, which we know will come down on Monday, and this will further complicate his efforts because what it looked like during oral arguments was that the court would kick it back to either the appellate court or to Judge Chutkan and say, you have to look at the elements of the indictment to determine which ones fall under presidential authority, which ones fall under personal/political conduct. That will require another hearing, and Jack Smith then will have to address this 1512C2 issue as well. So this case is really on shaky ground. Doesn't mean Jack Smith isn't going to figure out a way to make it work, and he has Judge Tanya Chutkan, who hates Donald Trump and is an Obama appointee, has given DOJ whatever they've wanted, so she will work hand in glove with him to try to salvage this indictment. But it's going to be tough as it proceeds, towards trial, if it ever does.
Okay, so timing on this. Do you think there's any way that this case goes to a jury or even starts the trial, given the desperation? Is it possible, like you said, the immunity ruling coming down Monday will be through July 4th, about 4 months till the election. You've been there for all that. Give us a sense on timing from your perspective.
Right. So let's say that they do exactly what I just laid out for the immunity order. On Monday, they kick it back down to Judge Chutkan. She will then have to schedule some sort of hearing. I assume that she will want to do it quickly, although she is going to be running in confrontation with what's happening on July 11th. President Trump's sentencing in New York. The week after that is the convention. Judge Chutkan has said she doesn't care about politics, so I wouldn't put it past her to schedule some sort of hearing that week. But let's say she does that and it's delayed towards the end of July. So this hearing would flesh out what I just said. Then she comes back with an order, might be quickly, maybe 2 to 4 weeks, says here it is. But then that has to go to the appellate court again, right? So timing-wise, it does not look like they would be able to pull off any sort of trial before Election Day because of all the now legal hurdles that the Supreme Court in this and then immunity has created for Jack Smith.
Julie, given that this is now this summer before the election, do you feel like the lawfare stuff that the Democrats have tried against Trump, do they recognize it as a failure and they're thinking about other options, or are they just likely to become more desperate, intensify, and perhaps, and this ties into July 11th, incarcerate Trump?
I mean, I think that they are going to triple and quadruple down. They are not recognizing how this lawfare is backfiring, working in Trump's favor. Furthermore, exposing the corruption of the DOJ, which we just saw with the 1512, right? And we probably will see with immunity. We are certainly seeing that play out in Southern Florida with Judge Aileen Cannon, where I'm following those proceedings, in the courtroom and all of the motions. We now know how sloppy and reckless and dangerous the raid of Mar-a-Lago was. They've mishandled evidence. So it's not just backfiring, people kind of encircling Trump and protecting him from this. It's backfiring in a way where it's making the DOJ, FBI, the judges look so much worse. So will they pull back? No. Will they incarcerate Donald Trump? Will Judge Merchan order prison time for him on July 11th? That would be tough. But in tandem with what we saw last night, you guys, with Joe Biden, obviously, they are going to get more and more desperate. So we'll see what other tricks they have up their sleeve. Now, again, you guys, we've talked about this. Jack Smith can still bring a superseding indictment against Donald Trump for seditious conspiracy. So that is not, now, this would relate to the immunity decision as well. But that doesn't mean that Jack Smith cannot bring more charges against him, even if he ends up dropping the 1512C2. Don't put anything past these people, including the judges. So we could be in for some real shocking surprises in this lawfare effort over the next few months as they get more.
I agree with Julie's maxim there. Do not, anything that is
Nope.
possible, they will do if they think it will help Biden, Clay.
Julie, last quick question for you, and I agree with Buck there. I think things have gone so awry for them, and they're now scrambling because they're significantly behind. Amy Coney Barrett wrote the dissent here, and Ketanji Brown Jackson signed on to the majority. How much would you have bet against that? I mean, because I'm still kind of floored by just the procedural posture here of the 6-3. I think it would have been 6-3, Amy Coney Barrett with the majority. What in the world happened there?
You guys, when I was reading and of course, as you know, I've been waiting for 3 years, but really the past 3 weeks for this. I had to reread the justices who were in concurrence and then dissent, because I couldn't wrap my mind around that Ketanji Brown Jackson was on the majority side and Amy Coney Barrett was the dissenting with Kagan and Sotomayor. But that was the fact. Even worse, you guys, is her dissent. It was childish. It was so basic. It was clearly political. She actually said Congress could never have envisioned something like January 6th happening. So they would not have even thought that this statute could apply. But of course it does. This is her line of thinking. What a profound disappointment she has been on this court. She's also had some really crazy votes in the past few weeks. And, what can you say? We're stuck with her now, but
Is she just trying too hard? Do you think that's what this is? To show, oh, you can't pigeonhole me in? Like, it's so strange to me.
It is, but it could be, but this is such a no-brainer.
I know.
Right? I mean, when you have the majority, including the Chief Justice who wrote the opinion today, so this was how serious this was, and you have Amy Coney Barrett siding with Sonia Sotomayor, who is a dunce. I mean, you listen to her in these oral arguments on what she writes. She is a dunce. She's half literate. And here she is protecting these two liberals and just giving the most overbroad and really, as I said, not impressive defense of her dissent here. Very extremely disappointing. So,
I will tell you, Julie, a friend of mine in conservative legal circles says that he believes Amy Coney Barrett is just trying to impress the people who went to law schools that she couldn't get into. It's a shot at Notre Dame, but I'm just saying that's what.
I'm always here for shots at Notre Dame. I'm in suburban Chicago.
I'm not trying to upset our South Bend listeners. I'm just saying that's
who
what I
is
was
your
told.
team, by the way, Julie? How do you hate Notre Dame?
Because I'm in suburban Chicago, and then Domers are the most obnoxious. I love many of them. I'm friends with them, but when it comes to Notre Dame, dear God,
that's funny.
Please give it. I went to Eastern Illinois. I don't even know if they have a football team anymore. I don't care. But anyway, shout out to the Panthers. That's my team.
Julie, stay in the fight. We're going to need to talk to you more as this keeps going. And I guess we can at least enjoy a good day today. So a good weekend ahead, I would hope. Thanks so much. Go check out Declassified with Julie Kelly on Substack, everyone. Julie, thanks.
Can't thank you guys enough for covering my work. Thanks so much.
Always. They didn't talk much about the debt last night, which I got to tell you was a miss in my mind. I don't think it came up really at all. And it's a huge problem. It actually goes beyond the presidential debate. It goes to the future of this nation, irrespective of who the president is, because it's $34 trillion, folks. You think they have inflation under control now? You think they're going to have inflation under control in the future? What can you do if they keep going in this direction? And they're going to have to keep printing and debasing. How can you take action today? Gold. History has the answer for you. Investing a portion of your savings in gold is a smart way to protect the value of your savings. That's why central banks, savvy investors, you see it going on all over the world. India has been buying huge amounts of gold, for example. I mean, some of these large countries are buying massive amounts of gold for their own holdings and reserves. They see what's coming. Gold survives economic downturns, and it's easy to own, whether you want it in your savings account or you can have it in your 401k or your IRA. Birch Gold is who we trust to make your first purchase or just your latest purchase of gold. For over 20 years, Birch Gold has helped concerned Americans transition an existing IRA or 401k into a tax-sheltered IRA in physical gold. It doesn't cost you a penny out of pocket. To learn more, get a free info kit by texting my name Buck to 989898. Again, using your phone to get the free info kit, text BUCK to 989898. Birch Gold has an A+ rating with the Better Business Bureau. Been in business for 20 years. This is who you want to work with. Text Buck to 989898 today.